this. Second one. Touch, yeah. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you so much. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Dillon. I'll be presiding today. To my left is Judge Jeff Carpenter. To my right is Judge Lucy Inman. Will be your panel today. We have one case on the calendar. It's State versus Barber, and if you're ready, we'll hear from the appellant. And please let me know if you'd like to reserve some time. I'll keep the time up here, and we hold pretty tight to this. But if we're firing questions at you, I mean, I'm going to let you close and finish your argument and whatever you want to say. But let me know if you want to reserve a little bit of time.
It is my intention to reserve at least 5 minutes, but I may not take my entire.
That's perfect.
25.
That's fine.
May it please the court, my name is Scott Holmes. I'm with the Durham County Bar. I'm here with my co-counsel, Ty Hunter, on behalf of Dr. Reverend Bishop Barber, who's present and in court. It's an honor to get to be here with you all and to argue on his behalf. Bishop Barber is here because he entered the North Carolina General Assembly on May 30th, 2017, with a group of doctors, pastors, and other North Carolina citizens in need of health care. They were there to try to say that it was important that Medicaid be expanded for the citizens of North Carolina who need that health care. They had tried to meet with legislators before and had been denied the opportunity to meet with the leaders of the General Assembly. Reverend Barber believed under Article 1, Section 12 of the North Carolina Constitution that it was his right to instruct the legislators at the General Assembly. He also understood under Article 1, Section 2 of the Constitution that everything done in the government should be done for the good of the whole. He was also motivated as a person of faith under Article 11, Section 4 of our North Carolina Constitution that, quote, beneficent provision for the poor, the unfortunate, and the orphans is the first duty of a Christian state. As he entered the General Assembly, they tried to go talk to the senators, the Speaker of the House, and the doors were closed to them. And so they stood in the hallway where they prayed, chanted, and sang. At some point, the officers believed that what they were doing was disturbing. And that word is important because it arises a lot in the transcript. It's also named in the legislative building rules, which were admitted at trial, as one of the time, manner, place restrictions of that public forum.
Had people made complaints by this point? Had employees made complaints?
There was some evidence from the police officers that they had received complaints, but because no one testified about it, there's no information as to what those complaints were about. The officers named that there were complaints, but it could have been the content of the speech and not the level of the demonstration that folks were complaining about. The only people who testified against Reverend Barber were police officers at the scene.
Did they testify? And are you saying they did not testify that the complaints were that they were too loud? That wasn't.
Well, at different times of the testimony, there were some different. The hearsay statements were. At sometimes the officers said that it might be that there were people in their offices. Some of the complaints had to do with other people, not Reverend Barber, in their offices. Some of the complaints, if I remember correctly, may have to do with the noise. But in general, it was a very generalized description of complaints and not specific complaints. And they were all anonymous. No one was named in the testimony as a particular person who had complained.
Mr. Holmes, there were, I've reviewed the transcript, and there were many hearsay objections voiced by Bishop Reverend Barber's counsel to hearsay. Nonetheless, there was lots and lots of testimony, and there was some testimony where there wasn't an objection. And as you know, the law as it is right now, if counsel doesn't object every single time, then whatever evidence has come in without objection is not going to be able to be challenged on appeal except for as plain error. And I think in some of those passages, one of the officers described noise complaints and again, without objection, which is because it's a different standard of review, described employees being concerned about their safety, leaving their offices and going other places in the building. What's our standard of review for that?
Well, that's a great question. With respect to the evidentiary standard of review, with respect to hearsay, for the objections that were preserved, that would be prejudicial.
I'm only asking about the ones that weren't.
That would be plain error, but zooming out, the question of whether or not there was a disturbance is really highlights the constitutional nature of our argument, because a disturbance is not an element of trespass. The only reason it became important in this case is because the state understood that Reverend Barber had a right to be in the General Assembly protesting, that it was a public forum, and no one could order him to leave unless there was a disturbance. And so this factual issue of whether or not there was a disturbance or not should have gone to the jury, but it did not, because that constitutional element, that this was a public forum, that this was subject to reasonable time, manner, place restrictions, was never, the defense counsel was never allowed to litigate that in court, and was not allowed, requested that to be sent to the jury by a jury instruction, was denied. So the very issue of whether or not there was or was not a disturbance is an issue of fact that should have been determined by the jury, but was not because
Well, let me ask you, I know one of the elements of trespass is more has to go on than just the fact that you were asked to leave. You have to have not been there with authorization, or you have to not have the right to remain. And I thought the evidence the state put on was this rule that if you're disturbing, they can ask you basically, I thought that was their theory, you're no longer authorized to be there. So why wasn't it before the jury? Why wasn't that before the jury, whether or not they were disturbing, breaking that rule, that legislative rule?
The element is whether or not a person with authority asked them to leave. And that really has more to do with whether the chief brought was a person with authority.
Well, I was talking about the element that he wasn't there with authorization.
Well, that's not an element of trespass. For example, if someone trespassed upon my yard, all I would need to prove is that I own the property or someone who I authorized.
I thought the statute said that a person without authorization is asked to leave by somebody in authority.
The statute says a person with authority asks you to leave.
But that you're there without authorization. I guess without authorization. That you're there without authorization.
Yeah, no, I could be wrong, and you should look at the statute, but my understanding is that the issue is whether or not a person with authority asks you to leave. And once a person with authority asks you to leave, then the presumption is maybe you're there without authority if you stay. But the problem with that is in public areas, that's not necessarily true if you're there under the protection of the First Amendment. And the only way that a person with authority can ask you to leave in a way that's unconstitutional, which is what happened in this case.
Just assuming for purposes of this argument that this panel agrees with you, I think the state has argued to the contrary, that this is a public forum. And that Bishop Reverend Barber and the other people with him who were there at the General Assembly standing in that space, take the noise out for a moment, okay? Assuming arguendo, because this is contrary to the evidence, that it was very quiet. I could understand why it might be disturbing to people in the building that there are people there petitioning for health care for people who are going without it. That can be, emotionally disturbing. But the evidence here is that there was sound, that there was noise. Do the time, manner, place, and manner restrictions that apply to the public forum allow the chief officer to say to everyone there, you're making too much noise, you need to leave now. If you don't stop making noise, not if you don't stop saying the content of what you're saying, not if you don't stop praying, but if you don't to turn the noise down, you're going to have to leave. Is it your position that that is a violation of the First Amendment?
Well, no. That under the First Amendment, there can be reasonable time, manner, place restrictions. One reasonable time, manner, place restriction would be not to disturb people or interfere in their ability to do their work. And the question then becomes, is that enforced in a reasonable way? And letting one officer or a couple officers decide what is loud and how loud is too loud raises an additional constitutional problem of unfettered discretion, that there should be some standard by which, and actually the state in their supplemental authority named a case either in Rhode Island or Pennsylvania where the court pointed out that telling people how loud is too loud shouldn't be in the discretion of police, that there should be some either decibel level or some objective measure of how loud is too loud when you have regular protest in a public forum where people work. And there have been regular protests in this public forum since 2013 at least. So they are aware that these folks return over and over and over to the General Assembly, and leaving it to one officer raises a different question, a constitutional problem of unfettered discretion. But generally, the answer is that it is okay, it is important for public forums to have reasonable time, manner, place restrictions, and having restrictions that prevent people from being disturbed in their work is a reasonable one.
And then a second question, you mentioned a requested jury instruction. What was the requested jury instruction? Because the state has argued that you haven't preserved that for appellate review.
So in the, when it came time for the jury instruction, the jury charge conference, the defense counsel requested an amendment to the jury instruction. It's on pages 407 and 408 of the transcript, and the requested jury instruction is on...
That's the legal right versus authorization?
Right. So what they asked for was that, to clarify the issue that you asked to begin with, is that it's more than just a person in authority asking you to leave, but that you didn't have the legal right to be there. And our law, even our state law, says that in public areas, there's a presumed right to be there unless you've somehow forfeited that right to be there, and that legal right would have been a more correct statement of the law than just the person had the authority to ask you to leave. And so that was the request, And it would have been a more accurate statement of the law in both our state and federal law to require that, and the judge denied that.
So, but just to be clear, it's not like you asked, and I understand you weren't trial counsel. It's not like trial counsel said, here's a proposed jury instruction on time, place, and manner, and the jury is asked to decide whether or not there was a reasonable response by the police to what was happening. There wasn't a request for an instruction about that, was there?
There wasn't more than the words legal right, but what the defense counsel said on page 48 of the transcript was that there is an additional element that needs to be proven because this is a public trespass, and that additional element is whether or not they had a legal right to stay. And to try to document that and put that before the jury, defense counsel changed authorization to legal right.
But if you have a legal right to be somewhere, and again, assuming arguendo, legal right to be there, if you have a legal right to be in the public forum, but are making noise that is outside of the bounds of the reasonable time, place, and manner restriction, isn't another issue whether or not the sound is at that level. In other words, whether you have a legal right or not, I'm grappling with why is that the additional element as opposed to what is the nature of the disturbance?
Yeah. Well,
And it doesn't sound like trial counsel asked for an instruction on that.
that's correct. And I think that there are a number of reasons why this case should be reversed, including a jurisdictional one, which I hope I'll get to. But on remand, if this court would clarify what is the law of trespass when it's a public forum, and what are the elements, that would be very important, because like a lot of other criminal statutes where the Constitution applies, the Constitution does apply to the law of trespass when there is a public forum and there are time, manner, place restrictions. And the instruction, a better instruction than legal right, would include that these particular, here are the time, manner, place restrictions, jury. It requires a disturbance, and this issue of whether or not there was in fact a disturbance is an issue of fact for you to find, because it is the jury's role to find facts and not the court's. So there would have been a better jury instruction, in retrospect, looking in the rearview mirror, that could have been proposed. But the attempt to try to incorporate legal right into the jury instruction was an attempt to try to accomplish that.
Would you concede that this happens all the time on appeal? The very best requests for jury instructions are often crafted in this room.
That's right.
In oral argument.
Yeah.
Long after the
We've been
trial.
working on this for months, isn't it?
Long after the trial. It's just the nature of it, and that's not enough to preserve an issue, though.
Well, that's right. The issue is preserved that there was a legal right to be there. That is preserved. And our argument is that the legal right flows from the Constitution, and the jury was not given the chance to determine that. Both the evidence of the constitutional violation was prohibited, the arguments about the Constitution were prohibited, and so at every stage that counsel tried to argue legal right, they were shut down, including the jury instruction, and all of that is preserved.
Would you agree that the legal right, you certainly have the legal right to come onto the property, but the trespass statute talks about remaining, and so could the legal right be, I guess, revoked, or if somebody goes to the legislature and is disturbing somebody?
Yes.
Yeah.
Yes. And the question in this case is whether or not there was an actual disturbance. And there is some hearsay evidence from police officers there were, but Reverend Barber said he was not. And actually, he was one person. He was not making all of the noise. He was not a person in other people's offices. The defendant in this case never got in front of a door. So a lot of the evidence with respect to what was disturbing was other people who are not charged and not before this court. So he should have had a chance to litigate before the jury whether or not he disturbed anyone.
And just in a nutshell, because I know your time is limited, just in a nutshell, if he were able to litigate the distinction between what you're talking about, what would he have presented?
I think a better jury instruction would have told the jury that the General Assembly is a public forum and that public forums subject to the First Amendment can have reasonable time, manner, place restrictions, and that there is evidence of that in the form of legislative building rules, Exhibit 2. And the factual question for the jury is whether or not this defendant violated those rules by disturbing. And the jury should find beyond a reasonable doubt that he in fact did disturb, that violated the reasonable time, manner, place restrictions, and thus he forfeited his right to remain in the public forum and therefore was subject to trespass.
Okay.
So you don't think the jury understood that that was what they needed to find?
They weren't instructed, so no.
Well, I mean, and I will say, where I read what the judge instructed was, I think to be guilty of trespass, the way I read the statute, is more has to happen than the fact that you were asked to leave. You had to not have the legal right to be there, like you said, or not have the authorization to remain. And so the jury was instructed that the defendant remained in the building without authorization. And so I guess you could see that two ways. One being you weren't authorized because you were disturbing, or two, you weren't authorized because somebody told you had to leave. And the second one probably isn't enough for trespass, because just because somebody tells you that you have to leave is not enough. You have to have no right to be there or to remain.
Okay.
Which highlights the difference between private and public trespass, because if you're on my property and I tell you to leave, then you have to leave, because private property, telling someone to leave means
That shows you don't have authorization
Right,
anyway. But if you're in a
right.
public place and you have the right to be there, just because somebody says you need to leave, if you have the right to be there, it's not a trespass because you didn't remain without authorization.
Right.
Is your argument? I'm trying to understand what you're saying.
That's my
And
argument.
you don't think the jury understood that distinction?
Well, because it wasn't without legal authorization, it was just without authorization. The language of the jury instruction, the jury instruction they were given had to do with just authorization, and there was no distinction made in the jury instruction.
And you think the jury understood that to mean just because somebody told them they had to leave, the state satisfied that element?
Yeah, because that's what it said. I mean, without authorization. And they asked in testimony, Chief Brock, are you authorized to tell people to leave? Are you authorized to enforce these rules? And it's like, yeah, I enforce these
Well,
rules.
that could go to the third element, which just says that you were asked by an authorized person to leave. But I guess, does the jury conflate that with the second one, that you didn't have the legal right to be there, which I think is another element the state's got to prove. And I guess in my mind, I'm just kind of rolling around. Did the state prove it by showing that there's this rule, and you can go to the legislature, but you can't go there and disturb people. And if you do that, you're not authorized to do that.
Well, I think you understand my argument, at least, and my hope is that in the future, this court will direct other courts to be more specific with respect to public forums so that the constitutional mandate is followed.
Right. I understand.
I'd like to turn just briefly to this jurisdictional argument, because like our other argument, this has evolved over the time to prepare for oral argument. And with respect to the jurisdictional argument, what I'd like to point out are the general statutes that I filed in a recent memorandum of additional authority. And the way I'd like to tell the story of this indictment and how the charges occurred. When Bishop Barber was bound in the General Assembly and taken out, he was charged on an arrest warrant. An arrest warrant brought him into district court because district court has original jurisdiction over misdemeanors. Well, when he got to district court, they did not try him in district court. He had no trial. And ordinarily what happens on a misdemeanor in district court is that you have a trial. If you lose, you have a right to appeal that to Superior Court. And Superior Court has jurisdiction over a misdemeanor on appeal. And the statute 7A-271 makes that clear. The only other way for a misdemeanor to get into Superior Court is by an indictment. Well,
Do you mean presentment?
well, first by presentment. And a presentment historically has been a mechanism for a grand jury to do its own investigation, to see that there's some crime in the world.
But it's got to be done by a grand jury.
It has to be done by the grand jury, and then they present to the district attorney, please go investigate this crime. The district attorney sees, yes, you were right, brings back evidence of it, and then there's an indictment. So a presentment requires an indictment after a presentment.
And there was an indictment here, wasn't there?
There was both a presentment and an indictment.
Does a presentment require investigation by the prosecutor between the presentment and the indictment?
This court's recent cases are kind of unclear about what's required. I feel safe to say that there needs to be some time between the presentment and the indictment.
And that happened here, right?
That did happen
That happened here.
So once the case ended up in Superior Court on the indictment, then there was jurisdiction. The Superior Court had jurisdiction over the indictment. Well, right before trial, the district attorney drafted a misdemeanor statement of charges, removing the name North Carolina General Assembly from the charging document. So the indictment named the General Assembly, but the district attorney, assistant district attorney, removed that language and filed a misdemeanor statement of charges. There was no motion to amend the indictment. The language was simply, Your Honor, we are going to arraign the defendant on this misdemeanor statement of charges. And defense counsel didn't object, and the misdemeanor statement of charges was, the court proceeded upon the misdemeanor statement of charges.
Not on the indictment.
Not on the indictment. Now, the problem with that is there are 3 different statutes, 15A-923, 15A-922, and 15A-642, which all say that proceedings on misdemeanors.
What was the last one? 15A,
642.
Thank you.
Say that all charges in Superior Court, when they are originating in Superior Court, have to be either an indictment or a bill of information where someone has waived the indictment. So there are 3 different statutes that say you cannot proceed on a misdemeanor statement of charges in Superior Court. And so the court has no jurisdiction. It's really that simple.
Why does the court not have jurisdiction under the original indictment? The misdemeanor statement of charges is not a superseding document.
The statute says, 15A-922, that when a misdemeanor statement of charges is used, it supersedes all other charging documents.
It can't be a superseding indictment in Superior Court based on the statutes that you've cited. It's not a proper process to give jurisdiction in Superior Court.
And therefore
the indictment is.
So, right. Well, they didn't proceed upon the indictment. They did not. He was never arraigned on the indictment.
Would you, does he need to be, would he need to have been arraigned? Sorry, Judge Carpenter.
Go ahead.
There was a presentment, there was an indictment. The presentment, the indictment, I would say the presentment initiated this case in Superior Court, but maybe not. Maybe the indictment initiated this case in Superior Court.
Together they did.
Okay. Then you have a misdemeanor statement of charges that supersedes the indictment. Does that undo the fact that, sorry,
That's okay. I can hear you.
does that undo the fact that the indictment initiated charges?
Right. I understand the question. Right.
Initiated as the statute.
Yeah. So now we are in this kind of metaphysical understanding of what jurisdiction means when you have an indictment and someone is arraigned on a misdemeanor statement of charges. There may be a number of legal ways to describe legally what happens in that moment. One thing could be that the court, understanding that misdemeanor statements of charges supersede all other charging documents under 15A-922A, that could mean that the indictment was dismissed by the prosecutor. It could mean that it's still there lurking around, but no one ever used it because there was never an arraignment on that indictment. But however you want to describe that legal moment in which Reverend Barber was arraigned on a misdemeanor statement of charges that changed the charge, changed the name of the owner, changed where this occurred, then that altered the trial, altered and deprived this court of jurisdiction. There's another way there have been recent cases that say that, and I have actually talked about it this way even recently in my supplemental statement, that maybe this was an amendment to the indictment. Maybe somehow this amended the indictment, but that's not the case either because
There's
no
only
motion.
one way to amend an indictment, that's to present a superseding indictment to the grand jury, if I understand
right.
the statutes correctly.
That's right.
So, question, was there a formal arraignment or the traditional informal arraignment where traditionally in trial courts, the defendants will waive formal arraignment and basically it's, Mr. Defense Lawyer, how does your client plead to second-degree trespass?
There was not a waiver of formal arraignment in the sense that there was a filing waiving formal arraignment. What happened was the district attorney said, we are going to arraign him on the misdemeanor statement of charges. He stood up. They asked, would you waive formal reading of the charging documents, which is different. It doesn't waive the arraignment. And he said, yes, we'll waive formal reading of the charges. Then they arraigned him. How does your client plead to trespass? He said not guilty, and they tried. So he was never arraigned on the indictment. The court has no jurisdiction. They were proceeded upon. And it's actually important strategically. Why would the DA remove the language, North Carolina General Assembly, from the indictment and feel it's important to proceed upon a different charging document without that? Because of the constitutional argument.
I could have missed something, but the only two changes that were purported to have been made was that Mr. Barber's name was a little different on the misdemeanor statement. I think it added a junior that wasn't on the original indictment, and then the removal of the General Assembly.
That's right. Those were the changes. Okay. Well, the legislative building was in the original indictment too, I believe, and so it just removed. And so even in terms of amendment, this didn't correct anything in terms of the location. It didn't add anything. It actually took something out. And so it was strategic on the DA's part to try not to raise this issue that this was the General Assembly, the people's house, where this trespass occurred. And for all of those reasons, this court just doesn't have jurisdiction.
So that you think it's jurisdictional. So you said there are two ways to do it. You could either do it by an indictment. What was the other way in Superior Court?
A bill of information, which means...
And this couldn't qualify as a bill of information?
No, because that requires a waiver of an indictment, a signed waiver by the party saying...
The waiver on the AOC form says that I waive my right to presentment to the grand jury.
That's right. And then indictment it goes back to 1166 in Henry II. It's enshrined in our state constitution, Article 1, Section 2, and our federal constitution, the Fifth Amendment. So playing with indictments is not something this court can tolerate, and it's jurisdictional.
I think I understand your argument, because clearly they can't charge another crime. But here they charge the same crime, but you're saying this is analogous to Wall, where it was the same crime, but we held that was error.
That's right.
Okay.
That's right. Because they'd also filed a motion in limine to prohibit arguments on the Constitution and the People's House. The state was very worried about getting information about the General Assembly to the jury. And one way they did that at the very beginning was this blunder of using a misdemeanor statement to supersede an indictment, which can't be done.
Well, I'll give you still have your 5 minutes because we've been firing questions, but
Well,
give the state more
I
time
have
if
a
you
little
need
bit of time.
it. And I'll give the state more time too if you need it. Thank you for your argument. We're from the state.
Good morning, Your Honors. May it please the Court. My name is Matthew Tolchin. I am an attorney with the North Carolina Department of Justice, and I represent the state in this matter. Your Honor, as much as the defense counsel would like you to believe, this case is just not about the First Amendment. It is about a defendant who, along with approximately 50 other people, gathered in the hallways outside the legislative leaders' offices and impeded people's entering and exiting and impeded the flow of the staff that were trying to walk in those hallways. And they also created a huge disturbance. Yes. Yes, Your Honor, and I think the record of this is clear that the Reverend Barber was leading this organization, and the evidence shows that he was seated outside the Senator Pro Temp's office in the hallway, and he was leading the chance. You're saying that because he was seated in the hallway, he was impeding the crowd? That is part, along with 50 other people in that area. And he's part of the group. Yes, Your Honor, I have.
Saying that one person sitting alone impeded, or you're saying that because all the other people were with him, that they impeded?
Your Honor, I think that's what the record reflects, that he was leading these people. And more importantly, with regard to the second aspect of it, is causing the disturbance and the noise, was leading the chants and the prayers. And there was the call and response, and there's ample testimony of this, Your Honor, that he would say something in what either he calls a church voice, or other people, particularly the witnesses that testifies, were an extremely loud, yelling voice. And then others would respond to that. And it went on and forth. And so, Your Honor, I think just about based on that abundance of record evidence leads to the second part of that, not only the impediment, but causing the disturbance. And that led to multiple repeated warnings by North Carolina General Assembly Police Department and other staff, Sergeant at Arms and so forth, requesting that defendant, specifically the defendant too, but also others in the area, to stop, lower your voice, stop making such loud noise, or leave the area, right? And there were multiple warnings. And when the defendant disregarded and refused to adhere to those warnings, he was arrested and charged with trespass, Your Honor. And that's what this case is about. It's about the trespass aspect. And so the state would ask you to affirm the decision of the jury below for several the following main reasons. One, the first is that the Superior Court had jurisdiction over this case, and I'm happy to get into the specifics of that in a minute. But second, more importantly, with regard to the First Amendment issue in this case, the defendant failed to preserve that issue for appellate review. And even if that issue had been preserved, I would submit that the First Amendment is not involved in this case. This case involves conduct. And third, even if the First Amendment was involved, defendants' rights to the First Amendment were not violated because the hallways outside the legislative leaders' offices are not a public forum. And the fourth is that there is more than sufficient evidence to support a charge of criminal trespass in the second degree. And finally, I would submit that the trial court properly instructed the jury on the necessary elements of trespass. So turning just to the jurisdiction argument, Your Honors, I think there's three specific provisions of the statute that apply here. And as you recognize, the requirement is that there's a presentment, which is in evidence in this case, and we, through a motion to amend, I discovered that in the course of preparing for this oral argument that copy of the presentment was in the court file, and so I submitted it to you for completeness of the record. But there's also an indictment. And so you're talking about the requirements under North Carolina General Statute 7A 271A2, which talks about jurisdiction of Superior Court. And that's the requirement that it be issued by a presentment. And then you get into the misdemeanor aspect, and that's governed by 15A-922G, and that's talked that if the Superior Court if they're going to proceed on misdemeanor in Superior Court, prosecution must be upon information or indictment. And the record clearly shows that there was an indictment in this case.
What about the argument that they didn't proceed on the indictment? Clearly, you can't have a misdemeanor statement of charge that charges a different crime, but you're arguing just because it's the same crime that was in the indictment, that's okay?
Correct, Your Honor, and that gets to the third statute, which I would argue that would apply here, and that's North Carolina General Statute 15A-922F, and this is sort of also the issue that the Supreme Court, North Carolina Supreme Court, recently discussed in State v. Capps, which is a case that was presented through a supplemental memo of authority by counsel for the defendant yesterday. And in that case, I mean, they talk about you can amend the pleadings or criminal pleadings in a case at any time, not as
You
provided.
can only amend the pleadings by motion being granted by the trial judge, though. You don't get to do that on your own accord. You make the motion with the trial judge, and the trial judge can either grant it or not.
Well, in this case, Your Honor, in terms of amending, but there's not even amendment. This is not in this case, there's no material difference from the indictment. This is talking about the General Assembly substituting that out for the Legislative Office building. The location is still the exact same. Indication of which building it was is still the same. Your Honor.
What's your response to the appellant's argument that this
Your Honor, the Legislative Office Building is still state-owned property, Your Honor, and this is, I mean, it's part of the same complex. And actually, I would submit that that's actually more accurate of where it occurred. It was outside the hallways of the Legislative Leaders Building. It wasn't in where the houses where the General Assembly met, and it wasn't even outside of those two. No, Your Honor, I think it was just more, I think it's a clarification in terms of just accuracy. It hasn't changed. He was still charged with the same offense, still charged with exactly the same place of where it was located. And I think, Your Honor, this is in terms of putting sort of form of a substance. I mean, the defendant was clearly aware, and I would submit to you that the defendant did not object to the statement of facts, the misdemeanor statement of facts that was filed. And so I would submit to you, Your Honor, because within those statutes, it talks about whether or not the defendant objects or whether or not they had enough time. There was no objection here, Your Honor. And then the other thing I would submit that the defendant was not the only, and this is in the record too, the defendant was not the only person who was arrested that day. There was almost 25 people who were arrested. And the trials for those cases were all done in Superior Court, Your Honor. And so I would think to operate differently, you know, just for this defendant, I would think would be.
I want to ask you about that. What's the reason, this is a big picture question, what is the reason to proceed on these misdemeanor charges in Superior Court? Other than to perhaps take away from the defendants the second bite of the apple that you always get when you have a trial in district court and then you get a trial in Superior Court. What is the reason?
Your Honor, I would obviously be speculating. I mean, in terms of why the prosecutor even went with the statement of facts.
Just in general, though, is there a policy reason? What is the reason?
I think the prosecution felt that with the size of it, the Superior Court was the better place. Plus, there were some constitutional issues raised, and there was constitutional challenge to the rules in some of those other cases, Your Honor. That didn't happen in this case.
Judges are not competent to review constitutional issues.
I'm not saying, I think perhaps from a judicial efficiency standpoint, they made a decision, but Your Honor, honestly, I would be.
It is efficient.
Yeah, I'd be purely speculative, Your Honor. I mean, I have no idea.
What if they, I mean, so you're saying it's not a jurisdictional issue, so if the DA had a statement of charges and charged a new crime, but the defendant doesn't object, the Superior Court can go ahead and try him under that, because it's been waived. I mean, even though the statute doesn't authorize that, it's not a jurisdictional, is that what you're saying?
No, Your Honor, I think in terms of, under the hypothetical you just said, that would be.
Yeah, assume there was never an indictment for this charge, but the defendant's there for another charges there, and the DA says, I want to proceed under this misdemeanor statement of charges I have, and the defendant does not object, he's found guilty. Can the defendant argue that the Superior Court never had jurisdiction?
I mean, I think that would be in violation of 15A 922.
I understand it's a violation of statute, but is it a jurisdictional? Because, I mean, statutes can be waived all the time. Rules of evidence can be waived.
You're right.
So would you say that that's something that could be waived, or is that something the Superior Court just cannot do? And even if it's not objected to down below, it would need to be vacated because there was no authority?
I think if there's no jurisdiction, you can raise that at any time.
So you think that's a jurisdictional thing if there's a statement of charges in Superior Court, misdemeanor statement of charges, even if the defendant doesn't object, there's no authority to convict him under that?
No, Your Honor. I would submit that there was lack of jurisdiction if there is a material and change that add a different charge. And I think that's what State v. Capps talks about, Your Honor, in terms of actually materially changing the offense. In this case, it was still second-degree criminal trespass, Your Honor. And there was really no material difference to the charges. Your Honor, turning to the First Amendment issue, I would submit that issue is not preserved for appellate review. And in fact, it was never raised in the case until the very end, after the close of all of evidence. After the close of the state's case, the defense counsel moved to dismiss only based on sufficiency of the evidence, Your Honor. And then after the defense rested the case, it renewed its motion based on the sufficient evidence, and then also argued the right to instruct, which is Article 1, Section 2. Never argued that there was a First Amendment issue from a legal standpoint, Your Honor. And I think, and I would submit that that was a strategic decision that was made by defense counsel, and the issue should have been raised prior to trial, and it would have avoided a lot of the jury instructions and a lot of the sidebars that occurred throughout the trial. But that was, defendants made a concerted effort and could have raised that issue during the motion to eliminate. They could have gotten into that, but defense made a strategic decision not to argue that issue. And so I would submit that that First Amendment issue is not preserved for appellate review. But even if it was preserved, I would submit that the First Amendment is not applicable in this case because this case involves conduct. The defendant was arrested and charged with trespass based on his conduct, not part of his speech. And the state submitted in a supplemental memo of authority in which it included a couple cases which I think are instructive with regard to this issue. And actually, you know, it's argument one is a Supreme Court case, so whether or not that's controlling is debatable. But the case I'm referring to is Virginia v. Hicks, Your Honor. It's 539 U.S. 113, and it's a 2003 case. And there's a passage which I think is most instructive is on page 123 of that. And this is a case where the defendant was challenging, it was a housing project, so it was a municipally owned property. And there was various rules with regard to trespass. They were trying to eliminate the flow of people who didn't live on the housing complex onto the grounds. And defendant had been trespassed because he had been there, he didn't live there, and he was there, and he was trespassed. And as part of the policies of the building, he was provided a barment sanction. So he was sanctioned barred from being on the premises in the future. And then he violated that barment sanction and was charged with trespass. And so, and argued that, you know, the policies and that, and being charged with trespass violates his First Amendment rights. And the court, in rejecting that argument, said, and I quote, "Neither the basis for the barment sanction, which is the prior trespass, nor its purpose preventing future trespasses has anything to do with the First Amendment. Punishing its violation by a person who wishes to engage in free speech no more implicates the First Amendment than would be punishment of a person who has, pursuant to a lawful regulation, been banned from a public park after vandalizing it and who ignores the ban in order to take part in a political demonstration." And then the court concludes, here, as there, it is Hicks, that's the defendant's, non-expressive conduct, his entry in violation of the notice barment rule, not his speech for which is he punished as a trespasser. And I would submit to you, in this case, the defendant is it's his conduct. He's punished as a trespasser, not for anything that he wanted to say or any message or expressive activity he wanted to convey.
And you say that issue was presented to the jury, whether or not Reverend Barber had violated the rule of the legislature and therefore no longer had a legal right to be there, or he was without authorization. Not simply the fact that he was asked to leave, but that he had done, that was before the jury.
And that would be the without authorization, Your Honor, and that's why there was so much testimony about the rules in this case, Your Honor. And I would submit that, Your Honor, these rules were enacted in 2014, and so there was a lot of, this goes to sort of the irrelevant and confusing evidence about Moral Monday protests and where they occurred and what happened during that. These rules were enacted after those, and actually in part as an outcome of those protests, Your Honor. And so those rules were very specific in terms of what they're called the rules of conduct for the legislative office building. And they set forth pretty clearly towards what conduct is considered would be disturbing, and then it's page 25, I think, of the record, which is a litany of things. And the other thing, Your Honor, about those rules is it provides, specifically designates an area in the legislative complex where people, for First Amendment activities, where people can gather to protest, to express their rights. And so within those rules, it specifically sets forth, establishes, and that wasn't the hallways of the legislative office building, it's other places on the grounds, Your Honor. And so, Your Honor, I would say, again, it's not a First Amendment issue, but even if the First Amendment is tied, it's not a defense to criminal trespass. And this is one of the other cases we submitted is United States v. Best. This is a district court case from Colorado, and this involved people who are protesting nuclear power. They trespassed on the grounds of this nuclear power plant, refused to leave, and there was actually a designated area on those grounds for protesting too. It was federal. It operated in part under the management of the Department of Energy, Your Honor. And so it was a public, I mean, that was sort of, and the defense has said we're enacting our First Amendment rights. And the court there says the First Amendment doesn't guarantee someone a right to break the criminal law. Freedom of expression doesn't mean freedom to make, ignore, or violate criminal law. And, Your Honor, the government has a right to manage its property. That does, and it can do it in a way that doesn't encroach on First Amendment. And this is what the United States Supreme Court pointed out in Adderley versus Florida. This is a 1966 case. This is where demonstrators, I think they were students from Florida A&M, were demonstrating on the driveway of the jail grounds. They were protesting the arrest of their other students for protesting segregation and civil rights. And in that case, the sheriff, who was the mayor of jail, asked them to leave repeatedly, and they did, and they were arrested for trespassing. And there, the court pointed out that there's nothing in the Constitution that prevents a state from enforcing general criminal trespass laws. And this is a quote, the state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. So, Your Honor, I would submit that the First Amendment is not at issue in this case.
The issue I'm having a little bit, I want you to explain to me, is this Wall case. And I'm not saying, I don't know if I agree or disagree, but it's the law, and we're bound by it, where somebody's found guilty at district court, you have the right to trial de novo, and you're tried for that charge. I mean, it's the charge you're tried for. But they didn't go through the right process. They did this statement of charges, which they shouldn't have done, and our court said that was reversible error, that they had no jurisdiction. How's that any different than this, where you can go to Superior Court and be indicted for a misdemeanor? You can be indicted for it. But they proceeded on this other thing, which I don't really see any harm or foul, but I have the Wall case that I'm stuck with, and if that's the law, I'm stuck with it. Why is this case any different than that? Because that's how you get to Superior Court, and it's the same charge, and I don't really see the harm, but Wall said it was fatal. So why isn't it fatal in this case?
Your Honor, I would submit that Wall is distinguishable, and I think we discussed some of the reasons why in the brief.
Well, you say it's distinguishable because he was prosecuted under an indictment, but he wasn't. He was prosecuted. I'm reading the brief, but he's prosecuted under the statement of charges. Here, he was prosecuted not under the appeal de novo, but it's the same charge.
In Wall, though, in the district court, he was charged under different crimes. And the indictment, the prosecutor...
I thought Wall was the same crime. It was the resisting a police officer. Is that not true?
It wasn't the crimes that he was tried for down below. And that's the reason that Wall found that there was an issue in that case. And this goes back to the material difference. There was different charges. They tried it on what was... And this is sort of like the double jeopardy issue. And one of the reasons why the statute prevents someone from saying, okay, you're in district court.
So you're saying in Wall he was not, you say in that case the defendant was charged for resisting a police officer. I thought that's what he was convicted of in Superior Court, resisting a police officer. It was the same crime, and that's where I thought that, I didn't know if Wall made a lot of sense to me, because Wall relies on an older case where the charge was different, and that might make sense to me. I don't know if Wall makes sense to me, but it's what we have. I think it was the same charge, but if it was the same charge, well, let me ask you this. If it was the same charge in Wall, are we bound by Wall then, because this is the same charge here? And
no, Your Honor, and there's another reason, too, why Wall is different. And again, if my memory of the facts of Wall is different, I apologize. But one of the facts that is clearly distinguishable is, in that case, the defendant was arraigned, and then there was a judgment entered in district court. And so within the statute, it talks about you can't file a misdemeanor statement of charges after there's been an arraignment and mostly you can't, especially after judgment. And Your Honor, I submit none of those things happen.
Well, you can't file a statement of charges in Superior Court anyway. So why is that any different? Because you're saying, well, he was indicted, so no harm. Well, here he's appealing de novo. In Wall, no harm, because you have the right to do that. But we held it was harm. We said it was harmful. So I'm trying to understand why this is different, Because I understand that that's what we held, you can't do that, but you can't do what was done here either. You can't proceed under a statement of charges in Superior Court.
I think in Wall, it's having two bites of the apple, Your Honor. It's not only after the arraignment, but also after the judgment, and I think that this is.
But you have the right to appeal in Superior Court anyway. The Superior Court has the right to try this case either by indictment or by an appeal de novo. They have the right to do it, and it was the same charge, but the DA, for whatever reason, did this statement of charges thing, which you're saying in Wall it was because it was after the arraignment, which you can't do, but you can't do it in Superior Court anyway. Again, I don't see the harm because I think Wall relied on a case that was different, where the statement was different, but we're stuck with it. We have Wall, so I'm trying to understand why the logic would be different.
I think there was also the other factor, which was present in the case, which wasn't present in Wall, in terms of, when we're talking about original jurisdiction, and that's what they're contesting here. It's not whether the Superior Court has jurisdiction to on the appeal district court. Here, in order to get original jurisdiction, you had to have a presentment and indictment, and that was satisfied in this case, Your Honor. So the Superior Court had jurisdiction over the case.
Well, why didn't the Superior Court have jurisdiction in Wall? Because they have jurisdiction to hear appeals de novo from district court. They have jurisdiction there as well.
I think, Your Honor, my understanding of Wall, the facts of Wall, I may have misread
And I'll go back
the
and
case.
reread it, but I think the charge was the same, but I'll go back and reread the logic of it. But
Okay, Your Honor. To going back, and Your Honor, I guess one of the reasons, in terms of subsequent to that, you have the State v. Capps case too, Your Honor, which I think, and I think there's language which, if you pause me a minute, I'll grab it.
yeah, please, and what's the site of Capps? Because I hadn't had a chance to read that one. Was that a statement of additional authority, I guess?
Yeah, so Capps is, 374 North Carolina 621. It's a
Okay.
2020 case. I think it was Chief Justice Newby wrote the decision. Although I guess at that time it was just Justice Newby. And this is pointing, I think it's pages 624 to 625. And essentially, their holding was that when a prosecutor's action is in substance an amendment to pleading, the amendment can be made at any time as long as it doesn't alter the nature of the offense. And so, Your Honor, I would submit to you in this case, the amendment of the pleading, or whatever you want to call it, the misdemeanor statement of charges, didn't alter the nature of the offense. And that's,
Can you amend a pleading, I guess as Judge Carpenter, can you amend a pleading without a motion, or can that be waived? Can an amendment, can the fact that you didn't make a motion be waived, I guess?
Your Honor, yeah, I think, Your Honor, that goes to the fact that he didn't object to any of that at that point. So you would waive that point, and the
Back to the issue of, if this is a subject matter jurisdiction issue, that can never be waived, right?
That's correct, Your Honor. What we're talking about is sort of amending whether or not you can amend the pleadings if you have to do it through a motion, and if that's when you're talking about amending the plea. You're not talking about a jurisdiction issue there. And if you don't object, if you waive your objection, then it's sort of otherwise the prosecutor just said, I move to amend the pleadings with the statement of fact. I mean, it's really.
So you can amend the pleading if the other party doesn't object?
Yes, sir.
I want to amend the plea, and the defendant says I have no objection to.
Yes, Your Honor. I
That's
think,
not a
and
movie,
that's
you
one of the
did it.
things where Cap points out, as long as it doesn't alter the nature of the crime charged, and that wasn't altered in this case, Your Honor.
So is it your position, I'm trying to understand the position the state's taken here. Is it your position, in effect, the misdemeanor statement of charges that Mr. Holmes has indicated was the document upon which Mr. Barber was tried, from the state's perspective, was in effect a motion to amend the indictment? Is that the position that the state's taken?
Well, I think, Your Honor, when you're looking, and this is sort of when it gets to misdemeanor charges versus and jurisdiction, I think it talks about criminal pleadings, and it covers several different categories within that. And whatever it's called, it becomes, whatever is filed then becomes the criminal pleading. So I would think it wouldn't be necessarily amend the indictment. It's a misdemeanor statement of charges. It's a separate thing.
We're talking about jurisdiction. The only way the Superior Court gets jurisdiction over a misdemeanor is, one, an appeal from district court, which didn't happen here, or two, a presentment from the grand jury an action by the grand jury presenting to the district attorney, investigate this case, and then the return of an indictment for the grand jury's consideration. So the pleading is the indictment for jurisdictional purposes, and we're talking about jurisdiction in this case.
Well, then, I guess, if then, in that term of view, I guess it would essentially amending the indictment, but it's not necessarily amendment if it's, because there's no material change. I think that's the part of it. It's still the same crime is charged, it's still the same location. And
Right,
so-
and had the state said, Your Honor, we'd like to amend the indictment, it's not a material change, the judge would have made a determination and, unless there was an objection, would have likely granted that motion.
Right, Your Honor. And so I think the trial court didn't seem to have any issues, and the defendant didn't object. So, Your Honor, just briefly, in terms of the First Amendment issue, I would submit that the hallways outside the legislative leader's office building are not a public forum, and that's, I think, pretty clear in some of the cases that set forth. And the reason
What about the defendant's argument that they weren't allowed to present evidence on that point, that they wanted to present evidence that maybe it is because, I mean, I don't know what the evidence would have shown, that, you know, maybe every day somebody goes there and is allowed to speak, but for some reason they weren't allowed to present the evidence.
So, Your Honor, first of all, it's a legal issue. And second of all, the evidence that they wanted to present is irrelevant to, and the trial judge had the discretion to allow it, whether to allow it or not, and preclude it because it's irrelevant and confusing to the jury, Your Honor. And the reason for that is they want to present evidence of past demonstrations that took place in the complex itself, Your Honor, at different times and different places.
Okay.
And, Your Honor, the fact that they took place there had no bearing on whether or not the defendant was or was not guilty of criminal trespass, Your Honor. And that goes through sort of the elements of the case. It's like if you got ticketed for speeding, Your Honor, and you argued, well, I wanted to put on evidence that there are other people who are driving on that road or have been driving on that road priorless, sped, and they weren't given a ticket. That's immaterial, Your Honor. It's irrelevant to the specific issue here, which was the elements of the criminal trespass. Again, if the defendant had wanted to raise the issue of First Amendment and the public forum, he could have done that prior to trial. And in fact, the judge ruled on that issue and determined that the hallways outside the legislative office building are not a public forum, Your Honor. And Your Honor, I would submit that we're not talking about the defendant's right to be in the hallways or even in the General Assembly at all. And as you pointed out, that with the public, it becomes a right. In order to be a criminal trespass, you have to be on the premise or remain on the presence without authorization after you've been told, instructed by someone who is an authority to leave. So, Your Honor, it's not the fact that the defendant was sitting in the hallways or present in the hallways. It's the fact that refused to leave or change the behavior in order to adhere by the rules. It was only after that refusal where they were arrested and charged with criminal trespass, Your Honor. And so I think to the extent that there was any sort of authority to be there, it was revoked. And I would cite just a couple cases which talk specifically about sort of areas of, and one case is Act Up versus WALP, W-A-L-P, at 755 F-Sup 1281. And this is a district case at a United States district court case out of Pennsylvania. There, these were AIDS activists. They wanted to protest the governor's speech, and they were barred from entering the gallery of the state legislative building. This is the galleries for Thunder. And so, in that case, the court ruled that that gallery was, in fact, a limited public forum, but acknowledged that people in that space, even though it's a limited public forum, can be removed if they're disruptive. And it acknowledged that there's a legitimate government interest in decorum in legislative office spaces. So, Your Honor, I would submit that even if it was some type of either limited public forum or even public forum, once you act in a way that is contrary to the government interest, and in this case is a violation of the rules of conduct, then whatever authority or right you have to be there is revoked.
I'll give you 1 minute to wrap up if you like.
Sure, Your Honor. Just a couple of issues. Judge, just to address the hearsay issue you're talking about, that issue was never raised on appeal. And I would submit that there's abundant evidence anyway in the record to support the crimes that are charged. And so, Your Honor, I would just, in conclusion, just say that this case is not about the First Amendment. The defendant was not arrested and charged for anything, for the content of his speech, anything he said, or anything. It's the fact that he did that, violated the rules of conduct of the building, refused repeated warnings to leave or to lower the voice or to alter their conduct and coherence or leave the area. Repeated by someone who's in authority, and he refused and disregarded that. And for that, he was arrested and charged with trespass. And so at the end of this case, we would ask you to affirm the jury's decision. Thank you, Your Honor.
so much. Thank you so much. About 5 minutes.
Thank you.
Tell me, the question I have for you is, if we're bound, Wall is something that I'm gonna have to go back and read, but also I need to go back and read Capps. So tell me why Capps doesn't take the sting out of your Wall argument.
Because it wasn't an indictment. Capps nor Wall were trying to amend a misdemeanor. And the rules about amending misdemeanors and indictments are different. Actually, our case is a stronger case for the lack of jurisdiction because the statute says a bill of indictment cannot be amended. The statute says that if you're going to proceed on a misdemeanor in Superior Court, it must be upon an indictment or information. 3 different statutes say that indictments cannot be amended by anything but a superseding indictment or by the consent of the defendant in a waiver of an indictment in a bill of information. So the reason why neither Wall actually at this point nor Capps apply to this.
So when there was no objection made, that wasn't good enough.
No,
Why? Tell me
because you can't waive a jurisdictional issue. Whether or not there's jurisdiction is a matter of law. It's reviewed de novo. It can be raised in any time. Parties cannot, by their consent, create jurisdiction. Just because I agree to it doesn't mean it happens. Jurisdiction the court only has jurisdiction created by the statutes. The statutes only create jurisdiction in this case for a misdemeanor in Superior Court by indictment. And it's as simple as that. Because he wasn't tried upon an indictment, the court has no jurisdiction, and he couldn't have consented.
Even though there was an indictment out there, they went on to this document.
They've conceded they didn't proceed upon that indictment, and the language is clear that he was never arraigned on the indictment. He was arraigned on an unlawful misdemeanor statement of charges. And they can't explain why they even did the misdemeanor statement of charges. They say there was no material difference, so then why do it? The answer is because it actually is a material difference, and that's actually a very nuanced issue in Capps. In Capps, they were allowed to amend the misdemeanor to change the name of the owner to a corporation because the 922F allows misdemeanors to change charges at all the times. That same amendment would not have been allowed if it were an indictment because changing the name is a substantial alteration and indictment under cases like State v. Abbott. So even in Capps, that shows the difference between amending an indictment and amending a misdemeanor. You can't amend an indictment the way you can amend a misdemeanor for legal reasons, but for jurisdictional reasons, you can't amend an indictment at all, except by a motion from a court, state the basis, and a ruling, which also never happened. The indictment, no one ever tried to amend the indictment here. All that happened was they arraigned him on a misdemeanor statement of charges, which was a mistake upon a mistake because they really shouldn't be playing around with presentments and indictments to get cases to Superior Court, which Judge Inman already raised. If you look at 922F, the statute that he just cited, saying that misdemeanor statements can amend most anything, it lists criminal summons, warrant for arrest, citations, and magistrate's orders. It does not say a misdemeanor statement of charges can amend an indictment. In fact, if you look at the very next statute, 922G, it says prosecution for a misdemeanor initiated in Superior Court is permitted only upon information or indictment. So the statutes themselves, on their plain face, say, even more than Wall, even more than Capps, those cases are actually distinguishable because they're misdemeanor cases. I mean, there's just no jurisdiction. With respect to this issue of whether or not there's a public forum, they can't have it both ways. They can't prohibit the defense from putting on evidence that the corridor has been used as a public forum and then say there's no evidence that there's a public forum. The problem was that from the very beginning, the court was not allowing them to put on that kind of evidence to show that this was a public forum. And the cases that the state cites that the Constitution doesn't apply, they all don't involve public forums. Each of them, a jail, a private neighborhood, a nuclear facility that's top secret, are not public forums. What this court needs to do is direct the state courts on how to deal with trespass when it is a public forum. And the fact that needs to be found is not just without authorization, because, you know, a co-tenant might have authorization, but still, you know, to stay. But a co-tenant in a private property is not the same as a constitutionally protected protester in a public forum. The legal right to stay there in order to be constitutional requires the jury to find that he engaged in a disturbance that forfeited his right to be in a protest. I'd be glad to answer any other questions. You've been kind to give me kind of more time, and my goal is to answer the jurisdictional issue. We briefed fully because these issues have come up during the course of oral argument. If the court wants some additional briefing on the issue of jurisdiction, but I'm glad to do that, both sides, but I also can answer your questions. 922F says misdemeanor statements can amend misdemeanor charges. It does not say they can amend indictments. In fact, 922G says when a prosecution of a misdemeanor is initiated in the Superior Court as permitted by 7A-271, which is presentment and indictment, then the prosecution must be upon information and indictment. 15A-923E says a bill of indictment may not be amended. That's the entire statute. 15A-923E, a bill of indictment may not be amended.
You got about 30 seconds if you want to wrap up.
15A-642, the court, in proceedings on the Superior Court, the court must proceed upon a bill of indictment or a waiver of indictment in writing. I think the assistant district attorney did not understand what they were doing, but they deprived the court of jurisdiction when they proceeded upon a misdemeanor statement of charges.
Thank you so much. Thank you for your arguments, and we'll take it under consideration. Thank you.
All rise. This session of the North Carolina Court of Appeals is adjourned.